Welcome to our training on Know Your Special Education Right. And I'm going to post a welcome in the chat. And we can get started. And just bear with me till I get that. So, welcome to Know Your Special Education Rights webinar. And we're glad everyone is here today with us in this webinar. So thank you very much for attending, and hopefully we'll have a few more straggling in. And just to let you know, this webinar is being recorded. So we want to say that in the beginning so y'all know. And this training is going to go over Know Your Special Education Rights. And so this was provided by one of our centers, the Families of Greater New Orleans, helped us with this presentation that we're going to go over today. So we want to give them credit. And this training is also going to cover parents' rights that are provided by the federal education law, which is known as the Individuals with Disabilities Education Act. And to ensure this training is helpful and relevant to you, we're going to be doing an area where you can give us your input. I believe it happens twice during the webinar. So you can give us feedback or your input on some questions that we ask. And hopefully this will help everyone with learning. And at the end of this webinar, we're going to do an evaluation survey. And the evaluation survey results help us to continuously improve the trainings that we're doing. So it should take you less than 2 minutes to complete the evaluation. And everyone completing the evaluation is going to get the PowerPoint and other resources from this webinar. And at any time, if you lose audio or video, you may call in using the phone number that's included in your registration confirmation. So if you get disconnected or having trouble, you may want to find your registration confirmation to use that to either call in or get back on. Like I said earlier, this webinar is being recorded, and we ask that if you have questions for us to please use the chat box, and we'll have time to answer questions, at the end too. So I'm here with Melinda Elliott, and my name is Wallace Johnson. And Melinda Elliott, we are your presenters for this training on Know Your Special Education Rights. And a little bit about us, Families Helping Families of Southwest Louisiana is one of 10 Families Helping Families resource centers that's part of a statewide network. We're all here, the Families Helping Family Centers, to provide support to parents of children and youth and adults with disabilities or special health care needs. And we do this through individual assistance, information sharing, outreach, and training. And this training was created with funding from the United States Department of Education to the Louisiana Parent Training and Information Center, which I said earlier, it's a program of Families Helping Families of Greater New Orleans. So in collaboration with the Louisiana Department of Education, this training is to be used statewide by the Families Helping Families centers. And so in order to continue to receive funding for these free trainings, we would like you to complete the evaluation at the end. And like I said earlier, these evaluation the survey helps us demonstrate the need for these trainings and demonstrate the need for continued funding, and also help us improve the type of training that we give to you. The trainings that we provide are free of charge. And so, anyone completing evaluation is going to receive a copy of resources from this webinar and our PowerPoint. So if you miss my email from you later on this afternoon about it, and you need to reach out to me again, I don't mind. Please contact me at Families Help Families, and I'll get the resources to you. Now I'd like to turn it over to my coworker, Melinda Elliott, so she can go over the LACAN program, the Louisiana Council's Advocacy Network. Take it away, Melinda.
Thank you, Wallace. So I have more than one role at Families Helping Families. One of the roles is education specialist. The other one is the LACAN team leader for Region 5. So Region 5 covers the same 5 parishes for Families Helping Families and LACAN: Beauregard, Allen, Calcasieu, Jeff Davis, and Cameron parishes. There's actually 9 people like me across the state, with one of us covering 2 areas in the New Orleans area. So if you're not from my area and you contact me, or you go to the website that I'm sure Wallace is going to drop into the chat box, you can find your LACAN team leader for your area. So LACAN is moms, dads, siblings, people with disabilities, providers, people that care about people with disabilities, that are interested in making home and community-based waivers and special education work better. So we advocate for changes in the system. We advocate with the legislature, and we advocate with Bessie. This is the hot time of year because legislative session is open. Every year, starting here shortly in July-ish, we do what we call it community input meetings, where we take input from all of the people that I named before, in webinars, on Facebook, from calls, any way we can get them, about issues that are affecting people with developmental disabilities or kids in special education. You know, people on the floor, people that are ground floor, people that are experiencing things that don't quite work right or don't seem to work fairly across populations, or just something isn't right with it. And we take all that information and put it into a document. The PD, Developmental Disabilities Council staff helps us put it into a document, and we rate it according to importance and whether we think there's a legislative fix for it. And we send our top 3 or 4-ish, as well as the entire list, really, to the Louisiana Developmental Disabilities Council, the council itself, and they come up with the legislative agenda from input from everybody, the ratings that we give, and their own experiences. So this year, 3 things made it to the top of the list. One of those is the Families Helping Families Centers for the past 3 years have gotten funding for increased costs. I know y'all's household costs have increased like mine. Well, it's no different for community-based organizations like Families Helping Families. And the legislators, we hadn't had an increase in years, and each center uses it for something different. I encourage you to call the executive director at the center where you live, the executive director of Families Helping Families, and she can tell you what they used the money for in the past 3 years. But it's not in the budget. It's not recurring money. We'd like for them to restore the funding this year and make it reoccurring money so that we don't have to ask for it every year. So then the centers could use it for reoccurring expenses, not just huge expenses that have gone up a lot or one-time things that the centers need. I mean, some of the centers used it to become up to date in technology. We learned how important that was during the pandemic, and even now afterwards, to be able to use technology to see meetings, to see trainings, to be able to talk to people. Anyway, that's one. The second one is all of the waivers in the state except the home and community-based waivers had the same rates for day and night hours. I really don't know, or I've been doing this a long time. I don't know or don't remember why the rate was different between day and night hours for home and community-based waivers, but several family members said that they thought that that was a big issue. I mean, there's a $5 difference. It's already hard for the amount of money that providers can pay to get staff. It's even harder when the providers don't have any wiggle room because they don't get the same reimbursement rate for nighttime. Not everybody's approved for nighttime. There's a process. You have to do various things to be approved. I'm signing out of my phone system. Sorry about that, you guys. I forgot. So we're looking for, I believe it was $8 million in the budget to bring the night rates up to day rates. Those two things, the Families Helping Families and the night rates, we've been doing serious advocating about, and looks like that they're going to happen. The third thing was that we wanted to eliminate the Family Flexible Fund. There's families on the waiting list. We're eliminating the waiting list, not the fund. And the amount of money to eliminate the people on the that waiting list has not made it into, I believe, the supplemental budget yet. We're still working on it. We still have our hopes on it. Some things take multiple years if families keep bringing them back to the table. So we will see next year if it doesn't happen this year. And if you have other ideas, y'all start talking to me. So what are you signing up for? You go to that website that Wallace gave you, you're signing up for emails. The emails are going to tell you what the issue is, what the background about the issue. Of course, I am hoping and will be contacting you to contact your legislator about how important that issue is to you, and or to a family member or friends or relatives. Some people will want to have a good story about those issues and want to be able to tell it. I'll help you put together a story that has some impact. And those stories are used in a lot of ways. I've seen them used in print media. I've seen them used in, I've been doing it a long time. I've seen people on individual visits, which I set up or you set up and I might be involved in with their legislator. I've seen people tell their stories at the legislative roundtable we have every January-ish. Ours is pretty well attended by the legislators. And it's going on in all the regions around that time of the year. A few people, because legislators we don't like to overwhelm them at the committee meetings in Baton Rouge, but a few people will be asked if they can go to Baton Rouge and tell their stories. We're always looking for people to do that, but not everybody does that. There's so many places to use stories and so many you know, differences in people's abilities to do things. But I mean, I even want you to be able to go to the local festival. I think over here it's the Rabbit Festival or something, and bump into your legislator and be able to tell your story. So basically, you're signing up to get the emails. Hopefully, there's other things that I'm going to do. I'm going to provide training. My major goal is to link you with your legislator. They don't want to hear from me. They've heard from me many, many times. Any questions? Let me look in the chat box. I see lots of things in the chat box. Wallace, someone saying thank you that we're recording the webinar. Thank you so much, Wallace. So he provides the link. You can go over there free, register. And Wallace, I believe I'm done. I'm going to give it back to you.
Okay, thank you, Melinda, for sharing that with us the information. All right, now we're going to do a quick icebreaker activity so you can use the chat to respond. And the question is, what is your favorite salty treat? What is your favorite salty treat? What is your favorite salty treat? So I see potato chips and queso, if I said that right, pretzels. Yeah, those are all good. I like Ritz crackers if that counts. Corn nuts. So that's some good choices. So I'm glad that our chat's working and everything. So now we'll move right along. Okay. Our learning goals for this training, we hope to increase your knowledge of frequently accused acronyms that are used in special education. And we also hope that you'll get information about the procedural safeguards and the language from the Individuals with Disabilities Education Act, also known as IDEA or IDEA. And your rights under the procedural safeguards, how they are identified or defined. Yeah, defined, I'm sorry. And we'll share website resources that where you'll have lots of good information to read and go over and have at your fingertips if you need it. And throughout this presentation, like I said, we're going to be using acronyms. I will always give the full meaning and state what it's known by, and then give the acronym. I might go back and forth occasionally, and so will Melinda, but we like to provide you with the following list of acronyms before we get started. Some of the frequently used acronyms you're going to hear in this training is LEA, which stands for Local Education Agency, or your local school system or your local school board. BESE is the Board of Elementary and Secondary Education. It's also known as the State School Board. And IDEA is the Individuals with Disabilities Education Act. IEP is the Individualized Education Program. FAPE, which is Free Appropriate Public Education. IEE, Independent Educational Evaluation. FERPA, Family Educational Rights and Privacy Act. And ERP, Early Resolution Process. And I'm going to give you a little bit of background. So President Gerald Ford signed into law the Education for All Handicapped Children Act on November the 29th, 1975. However, the original law was only for children 3 years of age and up. But for infants, it wasn't until the following year that birth until 3 their third birthday was added, which is now known as our Part C services. And in Louisiana, we call those Part C services early steps. The Individuals with Disabilities Education Act, also known as IDEA or IDEA, provides specific rights to students and parents of students qualifying for or suspected of or needing special education and related services. These rights are referred to as procedural safeguards. Those procedural safeguards are designed to ensure parental participation in the special education process and to ensure that students' rights to a free, appropriate public education, known as SPED. Procedural safeguards don't spell out what services you will receive, but they describe the ground rules for how you will work with your school. IDEA states that schools are required to provide you, the parents of a child with a disability, with a notice containing a full explanation of the procedural safeguards available under IDEA and the United States Department of Education. A copy of your rights must be provided to you at a minimum once per year. You should also receive a copy upon the initial referral or request for an evaluation, upon receipt of your first state complaint, or when a decision is made to take disciplinary action against your child that constitutes a change in placement, and they should also be provided upon your request. Your rights are also referred to as the procedural safeguards. Parents have the right to receive parental notification or parental participation. And this is very important. And we're going to talk about that a little more. Also, access to their children's records, to the educational records of the child, and to expect or confidentiality of those records of your child's information, to provide informed consent before certain things can happen, prior written notice, and receive information in a language that is understandable to you or in a way that's understandable to you, and receive an independent evaluation if you disagree with the school's evaluation, and stay put rights and dispute resolution options. Now we're going to talk a little bit more about each one of those. So this slide here is provides all the reasons in which you might want to do a dispute resolution or further do the due process. So this is a slide you may want to refer back to see if you have one of these that might apply to that situation. You have a right to a procedural safeguard notice. Your school must provide you with a written explanation of your rights, both under IDEA and Louisiana laws. You should receive those procedural safeguards notice every time you have an IEP meeting or in an evaluation. The purpose of the procedural safeguards notice is simple. It's to inform parents completely about their rights available under IDEA and Louisiana laws. This also includes protections that your child have as well. In Louisiana, this is the document, and it looks like the picture that's on the screen. It's called Louisiana's Educational Rights of Children with Disabilities, Special Education Processes, and Procedural Safeguards. I should also mention this, that the document comes in English and 7 additional languages, and you can download it from the Louisiana Department of Education website at louisianabelieves.com. So it comes in English, Arabic, Chinese mainland, Chinese Taiwan, French, Spanish, Urdu, and Vietnamese. A link to the Louisiana Department of Education's procedural safeguard notice will be provided to you in the resource section. One of IDEA's foundational principles is the right of parents to participate in the education decision-making regarding their child with a disability. This law is very specific about what school systems must do to ensure that parents have the opportunity to participate. Parents have rights to participate in meetings related to the evaluation and also related to identification and educational placement of their child. Parents have the right to participate in meetings related to the provision of free appropriate public education, also known as FAPE. Parents have the right to be team members of any group that decides whether their child is a child with a disability and meets the eligibility criteria for special education and related services. Parents have the right to be members of the team that develops, reviews, and revises the IEP for their child. An IEP is individual education plan or program. Parents have the right to be members of any group that makes placement decisions about or for their child. Section 1400C 5B of IDEA states that after 30 years of research and experience has demonstrated that the education of children with disabilities can be made more effective by strengthening the role and responsibility of parents and ensuring that families of such children have meaningful opportunities to participate in the education of their children at school and at home. So parental participation and protecting those rights of parental participation is extremely valued by IDEA and important. Parents have the right to see and get an explanation of their child's educational records. You can ask also for corrections and additions. These rights are protected by IDEA and the Family Educational Rights and Privacy Act known as FERPA. The participating school district must permit you to inspect and review any educational records related to your child that are collected, maintained, or used by your school district under IDEA. The participating agency must comply with your request to inspect and review any educational records on your child without unnecessary delay and before any meeting regarding an individualized education program, IEP, or in partial due process hearing, including a resolution meeting or hearing regarding discipline, and in no case more than 45 calendar days after you have made a request. Your right to inspect and review educational records includes the following: your right to a response from the school district to your reasonable request for explanations and interpretations of the records, your right to request that the school district provide you with copies of the records if you cannot effectively inspect and review the records unless you receive those copies, and your right to have your representative inspect and review the records. Each school district may charge a fee for the copies of records which are made for you if the fee does not effectively prevent you from exercising your right to inspect and review those records. The school district may not charge a fee to search or retrieve the records. Each participating school district must keep a record of parties obtaining access to educational records collected, maintained, or used under Part B of IDEA, except access by parents and authorized school employees of the school district, including the name of the party, the date of access was given, and the purpose for which the party is authorized to use the records. Any educational record includes information on more than one child. The parents of those children have the right to inspect and review only the information relating to their child or to be informed of that specific information. On such requests, each participating school district must provide you with a list of the types and locations of educational records collected and maintained or used by the agency. Parents have the right to expect the school to protect their child's information. Confidentiality information includes personal information such as your child's name, address, social security number, and other personal details. You have the right to expect your child's personal identifying information to be kept confidential. Personally identifiable information includes the previously mentioned information as well as a list of personal characteristics or other information that would make it possible to identify your child with reasonable certainty. Your school district must inform you of when personally identifiable information is destroyed. Your school district must inform you when personally identifiable information is collected, maintained, or used under IDEA is no longer needed to provide educational services to your child. The information must be destroyed at your request. However, a permanent record of your child's name, address, and phone number, his or her grades, attendance records, classes attended, grade level completed, and the year completed may be maintained without time limitation. Informed consent is another of your rights. Before a school district can evaluate your child or provide special education or related services for the first time, the school must inform you of what's involved. You have to give consent in writing. So it's important to note you have to give consent in writing before the school can move forward. Informed consent is one of your rights that's protected under procedural safeguards. Informed consent means you have been fully informed in your native language or in modes of communication of all the information about the action for which you are giving consent. You understand and agree in writing to that action, and the consent describes that action and lists the records, if any, that will be released and to whom, and you understand that the consent is voluntary on your part and that you may withdraw your consent at any time. Informed parental consent is required before the school can conduct an initial evaluation, the school conducts a reevaluation, and the school provides special education services. School invites a non-school agency to participate in IEP meetings to discuss your child's transition to adult life. So in each of those instances, you need informed consent. It's required from you before they can do any of those. The school district must make reasonable efforts to obtain your informed consent before providing special education or related service to your child for the first time. So that's extremely important. And if you refuse to give you such consent or later revoke your consent in writing, the school district may not use the procedural safeguards, which are mediation, due process complaint, resolution meeting, or impartial due process hearing to obtain agreement or ruling of special education and related services recommended by your child's IEP team. They may be provided to your child without your consent. Your school district is not in violation of FAPE and is not required to have an IEP meeting if you refuse to give consent or revoke consent. This is true if you don't respond to the school district when they request consent. The school must give you prior written notice before it changes your child's special education program. This includes when the school wants to add or deny any services. If a school wants to make changes to your child's IEP, you need to be informed and participate in the decision-making process. The prior written notice provision under IDEA states that the school must give parents prior written notice anytime it adds, changes, or denies educational services to their child or wants to change the child's placement. The content of the notice contains the following. It must have these. Describe the action that your school district proposes or refuses to take. Explain why your school district is proposing or refusing to take the action. Describe each evaluation, procedure, assessment, record, or report your school district is using in deciding the proposed or refuse of the action. Include a statement that you have protections under the procedural safeguard provisions in Part B of IDEA, and tell you how you can obtain a description of the procedural safeguards if the action that your school district is proposing or refusing is not an initial referral for an evaluation. Now we're going to do participant sharing time, and I'm going to turn it over to Melinda.
Great. So everybody type into the chat a 1 if you can hear me. That's one of the things I'm always worried about. Can people hear me? Groovy. Thank y'all. I appreciate it. So let's talk about what we've talked about up until now. The big deal was prior written notice, right? And like we talked about on, I think the slide right before this one, parents and schools overlook certain times when prior written notice is required. From a parent standpoint, it's important to know or to get the prior written notice because the school's supposed to give you really specific information on why they're saying they're going to do something or saying no, they won't do something. Schools are a whole lot better at providing that prior written notice when they're saying we want to do this. Usually when they're refusing to do something is when you don't get the notice that you're supposed to get. So I'm going to give you an example. I like examples. Molly receives 30 minutes a week of speech therapy as a related service on her IEP. Molly's mama doesn't think Molly is making enough progress, so she's requesting Molly receive 90 minutes a week of speech therapy. If the school refuses to increase her speech therapy to 90 minutes a week, Molly's mom must receive prior written notice. It has to explain why and what information they are using to make the decision. It's that type of notice that's going to help parents understand why the school isn't on the same page. Of course, reasons like lack of service providers, money, or other administrative issues are not something that the school system can use as a reason for refusing services. So if they do, we might want to have a discussion about that. I want y'all to type in the chat box where you think, and what you think other examples of prior written notice should be used when the school's denying a request. Not all requests fall under the requirements of prior written notice. So let's kind of talk about it a little bit. Let me open up the chat. So it looks like there are 14 of us in here, me and Wallace being 2 of them, so there's 12 of us. How many of y'all are parents? Just type it into the chat. You have 2 kids, Sabrina. Both of them receive special education services? Just one. You're a self-advocate, Wallace. I'm a parent and a grandmother, by the way. It's not like I won't tell people all the time. Anyone else a parent? Okay. So, not to call you out, but I know the answer already. Has there ever been times when you've asked for something and the school system has said no or just didn't do it? So, for one of the grands, we asked for occupational therapy. And the school system initially said no. And when we pressed for information, they said he doesn't qualify. And when we pressed for information, they told us why they didn't think he qualified. And we were able to come up with, my daughter and I were able to come up with things that he needed to know or be able to do, particularly at school. It wasn't necessarily handwriting things, but things that the other kids could do at that age that he wasn't able to do. And we were successful in getting them to provide speech therapy. No, said it wrong. Successful in getting them to provide occupational therapy. So, Sabrina says, yes, advocated for my daughter to not be in a separate room for testing. It took me talking to 3 separate people to get it done. And did they give you prior notice? Did they tell you why she had to be in a separate room? It was for hearing issues, but they had resolved. Yeah. So they resolved it before they sent you prior notice. Yeah. Well, good advocating. Though they were supposed to send you prior notice to tell you why they would or wouldn't do it. And so, sometimes you have to ask for it, and then, like you said, you have to talk to other people to be able to get it done. So let's go on to the next slide. So the school system is supposed to give you certain documents like prior written notice, procedural safeguards, and notices related to the due process complaint. If you choose, they can send you those notices by email. That became really important during the pandemic. And since we've all figured out that we can do that and that we can legally do that, it makes it a whole lot easier, at least for people like me, to be able to keep track of documents, because I'm better at organizing files on the computer than I am at organizing files in real life. So you have the right to get all information from the school regarding the delivery of special education services in a language understandable to you. Whenever the school provides you prior written notice, it's supposed to be in language, in normal people language that's understandable to the general public. It's supposed to be in your native language or your mode of communication. That could be Braille, that could be Spanish, that could be whatever. Sign language, particular type of sign language. If your language or other mode of communication isn't a written one, they have to ensure that the notice is translated for you orally or by other means that you understand. It's not enough to just read it to you. They are supposed to make sure you understand. And excuse me, they're supposed to write it down that those requirements have been met. When native language is one of the things that they have to do in an individual with limited English proficiency, it means the language normally used by that person, or since we're talking about students, in the language used by their parents. It's supposed to be the native language when they're doing the evaluation as well. I mean, the language that kids use at home. For a person with deafness or blindness, or if there is no written language, the mode of communication is what the person normally uses. You can get an independent educational evaluation if you disagree with the education evaluation of your child that the school district did. If you request an independent education evaluation, the school system has to give you information about where you can get it and about the school district's criteria that apply to independent educational evaluations. It's usually in the letter or the email that they send you after you request for the independent education evaluation. Independent education evaluation means that it has to be a qualified examiner. So it may not just be any psychologist or any doctor, but it's a qualified examiner that isn't employed by the school district that's educating your child. Then public expense means the school district pays for the cost of the evaluation or ensures that it's provided at no cost to you. That's consistent with the law, IDEA, the federal law, which allows each state to use their state, local, federal, and private sources of support to meet the requirements of IDEA. IDEA is never fully funded special education, so the law specifically talks about IDEA, the state and the school systems being able to use resources available to them. So you have that right to that independent educational evaluation at public expense if you disagree with an evaluation of your child that your school district did, subject to the following conditions. It isn't just a give me. One thing, if you request an independent education evaluation of your child at public expense, they have to do something without a unnecessary delay. They either have to file due process to request a hearing to show its evaluation of your child is appropriate, or they have to provide it in public expense. I mean, it's either the hearing or provide it, right? 2, if your school district requests a hearing and the final decision is that your school district's evaluation of your child is appropriate, you can still get an independent education evaluation, but not at the school's expense. Remember, it has to be an independent education evaluation by someone who's qualified to do what's called a 1508 evaluation, right? It's not just any psychological evaluation. It's one similar a lot like what the school system does. Now, if you request that independent educational evaluation, the school can ask you why you don't like their evaluation, but they can't require an explanation, and they can't delay giving you the independent educational evaluation at public expense, or like I said, they can file that due process complaint to defend their position. You're only entitled to one independent educational evaluation each time the school conducts an evaluation of your child with which you disagree. So if you get that independent educational evaluation at public expense, or you share with the school system an evaluation of the child that you got at private expense, the school district must consider the results of the evaluation of your child. It has to check if it meets the school district's criteria for independent educational evaluations. And any decision made with respect to the provision of the free appropriate publication to your child, right? And you or your school district may present the evaluation as evidence at a due process hearing regarding your child. If the independent educational evaluation is at public expense, the criteria under which the evaluation is obtained, including the location of the evaluation and qualifications of the examiner, must be the same as that the school district uses when it initiates an evaluation. All right? Is that clear as mud? Does somebody need me to explain some more? Chat me up. No? We good? All right. So, more about your rights. What's a stay put? A stay put is something that can be used when you disagree with a proposed change to your child's IEP services or placement. Stay put keeps your child's current IEP in place while you and the school system work on a solution. That stay put provision allows you to dispute a change without the change taking effect. It includes all IEP services, including the related services. When you use stay put, your child services continue as is without any changes. And then ideally, the parents and the school are working together to come up with a solution. There are occasions when schools and parents can't find a resolution. I want you to know a few things, important things about stay put. Parents can only invoke their stay put before the change occurs. The prior written notice that we spoke about before must be sent to you notifying you before the proposed change. That's one of the other reasons why that prior written notice is so important, and then you should make sure you get them. Once you invoke that stay put, you need to do something. That's usually done through dispute resolution process that we're going to talk about next. If you go through this one of the dispute resolution processes, the school system is required to keep your child in the current placement and keep those same services until a decision is rendered through that process. There's one exception to stay put. The school can move your child for 45 days, even if you disagree. If your child violated the most severe student code of conduct of having a weapon or illegal drugs on the school campus. So let's talk about those dispute resolution options a little bit. There's a whole workshop about this, but let's talk about it a little bit. Sometimes you disagree with the school district about your child's education, and y'all can't come up with a resolution. Under IDEA, you get additional rights when you need a more formal process to resolve your dispute. You can use those processes to come up with a resolution around your child's disability identification, their evaluation, their eligibility, their placement, their services, or reimbursement of services you've obtained privately. The first one is the IEP facilitation. That it's non-adversarial dispute resolution method that's offered by the Louisiana Department of Education. It's free for both the parent and the school, but both the parent and the school must agree to the process. And if they do, the state's going to assign a neutral person called an IEP facilitator to help with the process. The next one's mediation. That's another way to do this. It's also voluntary. It also requires an agreement by both the parent and the school. And then the next complaint dispute resolution process are informal complaints. It's the policy of the Louisiana Department of Education to encourage and support prompt and effective resolution of a complaint in the least adversarial manner. The way that they do that is with the early resolution process, ERP. That's used by each school district and draws on the traditional, the years and years model of parents and school districts working together in the educational interest of the child to receive shared goals of educating a child with a disability. Then there's a lot of these. There are formal complaints. Those are developed under the supervisory role of the Louisiana Department of Education, LDOE, to address allegations the school district is violating a requirement of IDEA, the Individuals with Disabilities Education Act. A parent, adult student, individual, or organization can file a signed written complaint by U.S. mail, fax, email, or telecommunication for the deaf with the Louisiana Department of Education. Then the due process hearing is the most formal of them all. That process is more like a court proceeding. Evidence is presented to an independent hearing officer to resolve a dispute between you and the school district. Only you, your attorney representing your child, or the school district can request a due process hearing. Using the complaint and dispute resolution process should always be your last resort, the very last thing you tried to do after you try to do it more agreeably. You can contact Families Helping Family Centers with assistance in resolving your issues. And then, like I said, we have a whole workshop about dispute resolution options where we go into these in detail. Just let us know if you're interested in that. That's part of what Wallace was talking about on the evaluation. You can tell us about things you need or want. So let's have a little bit of sharing again. let's talk about the reasons to use the formal dispute resolution process. First, you got to keep in mind the parent has to have a reason that's required under IDEA, the Individuals with Disabilities Education Act. Drop me a note in the chat. What would be the reason? So like, if you work with children in special education, you might know a reason. And then, of course, if you have a child that receives special education services, you might have bumped into reasons. Oh, let me see. Wallace is saying failure to provide the prior written notice, the PWN. Yeah. That should be one of the things that you could and should complain about in the dispute resolution process. Anybody else? So we talked about a few minutes ago, not providing either a due process complaint or just providing the independent education evaluation. It's called for in IDEA, and it's something that you can use one of the dispute resolution processes with. Not providing FAPE, yeah, that's another one. Okay. Well, those are good. Let's go on. Next, we have a list of the resources to help you better understand parental rights in special education. These are this is the websites that you can go to and particular parts of the website. So the first one is the Louisiana Department of Education. They call their website Louisiana Believes. Then the others are specific parts of the federal law that you can go to, specific parts of IDEA. More specific parts of IDEA that can help you and explain what they expect. We're going to send you some handouts. We're going to send you the Louisiana Educational Rights for Children with Disabilities. Excuse me. The Louisiana Department of Education Resources for Parents of Students with Disabilities, the Louisiana Sample Parental Notification Letter, the IDEA Model Prior Written Notice Form, and something about collective advocacy. And Wallace will drop the link if he hasn't already, because he's fast, for the evaluation. Please do the evaluation. You're going to get an email later with it, but please do the evaluation because it helps us improve our trainings, and we want to continue to do these trainings for free. We're going to send y'all a copy of the PowerPoint and a certificate of attendance if you need it. Let's see. So now we've gone through special education rights. I hope y'all have learned a few new things. If you have a question that wasn't answered, you can chat me up right now, or you can send me an email later. I appreciate y'all participating. And don't forget to look at our FHFSWLA.org website and our Facebook page about upcoming trainings. Let me check the chat box again. Ooh, y'all are an easy crowd. No questions. So I'm gonna hang out for a few minutes. I appreciate y'all being here today. I know it's the end of school, but I really appreciate y'all being here. And even though I'm gonna mute, chat me up if you have questions.